Welcome to the Immigration Insights podcast. This installment is brought to you by myself, Nick Gore,
Carla Mirallas Martinez,
Cathryn Davies, and Sarah Jabir.
all of Carter Thomas Solicitors fame. In each episode, we discuss the latest news and developments in UK immigration law, brought to you by a leading specialist immigration law firm. So on 12th of March, we were treated to a new statement of changes, which is the main way the government can change various immigration rules. So we have plenty to discuss today, and not like we're ever short of topics, to be honest with you. We'll also take a closer look at the EU settlement scheme continuous residence today by our very own resident specialist, Carla, so do stay tuned. But it's become somewhat of a feature to kick off with the latest fee increases. So Cathryn, would you like to run us through what those are?
Yeah, absolutely. We should probably find a more positive note to start on, shouldn't we? But yes, so the government has announced that the latest wave of fee increases will come into effect on the 9th of April. We did have some prior warning of a small amount of these earlier in the year, which we have discussed previously. However, amongst those initial insights that we had, the Home Office have also taken the opportunity to increase almost all visa fees. But yes, so some key fee increases to note are the route to settlement fee, which applies to partners applying for entry clearance, is increasing by £92 to £1,938, which is massive. Skilled worker application fees are increasing by £50 or £99, depending on whether it's an up to 3 or 5 year sponsorship. Fees for leave to remain applications are increasing by £63 to £1,321. This fee increased just last year by 20%. So it is obviously concerning to see this being increased again so soon. The fee for naturalisation is going up to £1,605, which with the ceremony fee takes this to £1,735. The fee for indefinite leave to remain is going up by £144 to an absolute whopping £3,029. And of course, the fee for ETAs, which has increased to £16, despite the scheme only having been run for a minute. But of course, the heftiest fee increase is for certificates of sponsorship, which has gone from £239 to £525, which is a really significant increase. So, as we've discussed previously, the UK's visa fees are amongst the highest in the world, which we expect are quite prohibitive now to a number of individuals, and perhaps even for businesses as well. Nick, have we seen any concern from business clients regarding the fee increases?
Yeah, absolutely. As you say, the COS fee in itself has gone up by quite a significant amount. That has to be paid every time you want to sponsor a worker. In addition to that, many sponsors do cover the costs of the skilled worker application fee as well, and that's going up also. I was thinking, compared to say last year, when you had the lower salary requirements of in the 20s normally for most workers, and you had the lower fees, the changes from last year to this year with the increase of this minimum salary requirement to 38,700 at least in most cases, plus the increase in fees that we've seen here and throughout the year, it's a huge increase. As we've talked about before, this is one of the main levers the Home Office have to try and reduce immigration by just frankly pricing people out. So businesses are certainly encouraged to basically not look for sponsorship of workers because it's so expensive now, both to pay them and to pay to go through the process. So that's really frustrating. And then on top of that, most of the fees you've covered there, Cathryn, are for individuals. Naturalisation, that's a fee many people frankly get frustrated to pay, especially if you're, say, going through the EU scheme, which Carla will talk about later, which is often free in most parts. Then you have to pay a whopping fee to become a British citizen. There is some discussion, has been for years, about the various fees you have to pay to register to become a British citizen. That hasn't changed at this point. But to register as a British citizen is something many people are entitled to, and you have to pay an enormous fee for that. So it is incredibly frustrating, the various Home Office fees, as you say, the highest in the world or amongst the highest in the world. And it's part of this wider narrative to really try and reduce immigration by pulling the levers that the Home Office can pull. So Yeah, frustrating to see, and certainly a lot of concern both across business and in individuals as well.
Yeah, it's a complete double whammy, isn't it? Especially, the changes to the naturalisation guidance coupled with the fee increases and the same for skilled workers. It's definitely a kind of two-pronged attack that we're seeing. And we're seeing that as well, reflected now in the numbers of visas that are being granted. So the Home Office released figures in February on the numbers of visas being granted. And this has shown a significant fall in the numbers of visas granted to individuals moving to the UK on work, study, family, and other visa categories. So the numbers have fallen by 460,000. In our first episode, we discussed the changes to the health and care worker route and the student route that stopped and limited applicants being able to bring their dependents. So these are the areas that are mainly contributing to those figures. So for example, visas for health and care workers and their families have fallen by 68%, and student dependent numbers have also fallen by around 85%.
Gosh.
Which is really, really huge. And 2024 also saw really significant changes, as you've just discussed, to the salary thresholds for skilled workers. So we can see that reflected in these figures now. So following the increase in salary thresholds, between July and December 2024, grants for skilled worker visas, this excluding health and care visas too, these fell by 39% compared with the same period in 2023. So we're seeing quite a big hit there. The food and hospitality sector, interestingly, has taken a big hit. So comparing the same period in 2024 to that of 2023, visa grants fell by 73% for those in that sector. And we also discussed the minimum income requirement increase for partner visas in our first episode, which saw the threshold increase from 18,600 to 29,000. But interestingly, despite this, the grants of partner and family visas haven't taken as big of a hit as other areas. So there has been a decrease. Grants have decreased by 8% in the second half of 2024 compared to the same period in 2023. I find this quite interesting because we're seeing lots of individuals who are struggling with the salary increase, and especially the prospect of that potentially increasing further. So yes, interesting to see that there's not been a huge decrease there, but a decrease nonetheless.
Yeah, I mean, it just shows that it's one of these routes that you basically have to have. So you can increase the salary all you like, but people still want to bring their partners over to the UK, and it's just making it personally more painful for individuals, isn't it? Whether it's 18,600, 29,000 or more, people will try and scrap up the money because it's for a family member. So as we've talked about before, it's frankly just a cruel change. This one.
It is, yeah. We're seeing clients that are really kind of desperately trying to bring those funds together, and also looking at, perhaps exceptional circumstances and whether they can apply it on that basis. So yeah, it's just a way of muddling through, really, which is just making it really, really hard for people. But people are still, managing to apply nonetheless, which is good, I suppose. But yes, so we've also obviously had a new statement of changes since our last episode, which has seen further restrictions again relating to recruiting care workers and the skilled worker salary requirements. So it will be interesting to see how this progresses further as it becomes more and more difficult, seemingly. But yes, so Sarah, would you like to discuss the latest statement of changes?
Thank you, Cathryn. Yes, of course. So as Cathryn was just saying, we had another statement of changes on the 12th of March, so just a few weeks ago now. So there's a huge number of changes, which we do have an article on our website about if you'd like to go more in depth into this without reading the whole, I think it's nearly 150-page document on the changes that they've made, which is quite substantial as always. So one of the main requirements, which they've been doing quite a lot recently, we've seen it with Jordanian nationals, and then we've seen it with Colombian nationals as well in the last year. So nationals of Trinidad and Tobago, which is a Commonwealth state, are now subject to visa requirements, and they've been added to Appendix Visitor there's a 6-week transitionary period, and it basically means that they have been removed from Appendix Electronic Travel Authorization, which is the ETA. So this is the electronic travel authorization for non-visa nationals who want to visit the UK. So that includes, members of the European Economic Area, Switzerland, Australia, USA. They've been taken off that. They now have to go through the traditional kind of visit visa route and prove all of their ties to their home country and other things that they have to do. So as they're now subject to visit visa requirements, they're no longer permitted to benefit from the ETA scheme, and they have to demonstrate that they're genuine visitors. This is due to a spike in asylum claims in the last year, where nationals of Trinidad and Tobago have entered the UK for what the Home Office calls purposes that are not permitted under the immigration rules for visitors, such as to live, work, or claim asylum in the UK. So obviously this is quite a kind of convoluted way of saying we don't want you to come here as a visitor, as we've been allowing you, and not have to do an immigration application or anything like that, and then just stay and claim asylum or try and work. So this has been quite a significant increase if we look at the figures, because between 2015 and 2019 there was actually only 49 asylum claims per year between those years from nationals of Trinidad and Tobago, whereas in only the last quarter of 2024 it has increased to a whopping 209 asylum claims that were recorded. So obviously this has increased, nearly tenfold, because that's just in one quarter as well. So this has led to the implementation of the visa requirement for nationals of Trinidad and Tobago. And interestingly, it's been adding to the list of Commonwealth countries which have been placed on the list, such as Jamaica and Dominica. However, the UK government has maintained that this will be kept under review, and obviously we have quite strong diplomatic relations with this country, so it'll be interesting to see how that progresses. And just as I mentioned before, there's also a transitionary period of 6 weeks, which should allow for nationals of Trinidad and Tobago who'd already obtained an ETA and had pre-booked travel to the UK to benefit from the previous rules. So they won't have to apply for the visit visa and pay the fees and submit all of the evidence required with that. So the ETA application scheme for nationals of Trinidad and Tobago closed at 3 p.m. on the 12th of March. So it's quite a sudden change, because the statement of change was also published on the 12th of March. And the nationals will also now have a mandatory obligation placed upon them when transiting through the UK to apply for a direct airside transit visa. So we did also discuss this, I think, in around October last year on our website, when we had another statement of changes where they put Jordanian nationals on this list as well. So it's quite similar in that way. So another change that has happened is one that's quite significant to the recruitment of care workers. So this tends to only apply to care workers in England. And it's quite an interesting update that's been outlined in the Statement of Changes that comes into effect on the 9th of April 2025. And it basically states that any care homes or care providers in England, because the ones in Wales, Northern Ireland and Scotland are largely unchanged, unaltered, who wish to recruit any foreign workers who are based outside of the UK must demonstrate that they've firstly attempted to recruit a worker who's currently based in England and requires a new sponsored role. So this is people who are displaced workers, for example. So if they worked for a care home who's had their sponsor license revoked, and then they're put onto a kind of list, and you have to kind of prove that you've gone to your local regional care partnership authority, which is some new authorities that have been set up by the government. So once the care provider's gone to their local regional care partnership, they have to acquire evidence that they've genuinely attempted to recruit from existing and displaced workers within England prior to sponsoring workers who wish to enter from overseas. So the kind of responsibility and onus is on the local care providers themselves to ensure that they've prioritised workers who are currently in England and need a job. And it's also important to note that this doesn't affect skilled workers who are currently sponsored as care workers prior to the change taking place.
Yeah, quite an interesting change, this one. It seems the Home Office largely sort of cleaning up their own mess, frankly, because they gave a lot of sponsor licenses to a lot of dodgy care homes. We've
Yes.
seen quite a few examples of care homes acting really quite dishonestly, and almost we've seen cases, and there's been a lot of talk about basically modern day slavery cases of essentially keeping people in the UK through sort of financial bondage. They're covering their fees and saying, you can't leave this employment unless you pay back an enormous sum of money. People being brought over on quite on grounds of which they weren't quite aware of all the sort of consequences. So it is good to
Yeah.
see the Home Office realizing that there's a huge amount of people in the UK who've had their licenses, who are no longer able to work, because their licenses have been revoked, because the Home Office very correctly have taken those licenses away, which they actually gave to them. And this is almost akin to there used to be something called the resident labour market test in the skilled worker route, where essentially sponsors would have to try and demonstrate that they've tried to recruit a local worker before they could sponsor someone from outside of the UK. And this is almost the same thing, but for a very niche area within the UK. So overall, seems to be a relatively positive change from the Home Office, which is always great to see. But as I say, it is a case of them cleaning up their own mess. Frankly,
Yeah.
Why a lot of these care homes had sponsor licenses in the first place is something that should be looked at.
Exactly. And like you're saying, it is, hopefully will help to stop exploitation of foreign workers who enter the UK and kind of end up in those vulnerable positions with, sponsors who have had their licenses revoked or acted dishonestly, or, probably quite frankly shouldn't have been granted the license in the first place.
Yeah.
So it'll be interesting to see, because it's obviously a field in the UK that requires a lot of workers. So yeah, and this is also all part of the government's wider plan for change, which includes linking immigration skills and visa systems to grow domestic skills and end reliance on overseas labour and boost economic growth. So there's a lot of different parts of the plan for change that span outside of immigration law as well, but they're trying to tidy up the immigration system, especially with this new Labour government as well. So another change that we had was the salary requirements, which Cathryn briefly mentioned earlier as well. So last year we reported on the significant changes to the skilled worker minimum salary requirements. These, increased massively, exponentially, and like Nick was saying, priced out a lot of sponsors and businesses from being able to actually afford to sponsor foreign talent and attract foreign talent to the UK. So the minimum salary floor has now increased from £23,000 200 a year to 25,000 a year following the government's annual salary reviews. This was slightly expected because, the very minimum with all of the discounts and everything else that's applicable should always be in line with employment regulations and laws in the UK as well, such as national minimum wage and things like that. So that is something that obviously sponsors have to comply with. Additionally, on that note as well, healthcare and education roles have also had their minimum salaries updated in line with recent changes, and other skilled worker roles have been amended to reflect the new minimum salary threshold of 25,000 a year. So the going rates online have now been updated with the skilled occupations, which is good. So they're just kind of bringing everything in line, tidying it up a bit. We expected this is, less of a significant increase than what we saw last year, which was massive. So hopefully, we shouldn't see too many difficulties with this, but only time will tell. And then that also affects natural scientists as well, which is interesting. Some of the natural scientist roles, some of which are exempt from the ISC as well, the Immigration Skills Charge. They've had their salaries raised as well. So also for new entrants, the Statement of Changes did clarify that the qualification must now be from a UK-based institution if relying on training towards a recognised professional qualification. So new entrants have some sort of discount, which means that they can be sponsored for a lower rate. So it tends to be people who are under the age of 26, or if you're transitioning straight from a student or graduate visa to a skilled worker visa, amongst other things. So they have this new restriction imposed upon them if they wish to benefit from these reduced salaries in skilled worker roles. And previously there was hardly any restrictions on which country a qualification could be achieved in when studying towards a recognised professional qualification. However, this statement of changes a few weeks ago has clarified that the qualification must now be from a UK-based institution in order to qualify for the new entrant salary rates. This could negatively affect certain professional qualifications where the regulatory body in the UK specifically recommends a European training route, for example. So one thing that we've seen to do with this is veterinary professionals. So vets, their regulatory body in the UK actually recommends a European qualification. And, you know, some of the, especially local vets, really want to benefit from the new entrant rate because it's helping them obviously reduce the salary for the worker. So yeah, it'll be interesting to see if there's any further clarification on this, or if the Home Office does, you know, cooperate or listen to regulatory bodies and see if they wish to clarify or have a bit of leeway here and there with that. So care should be taken when sponsoring a new entrant so that the organisation remains compliant with their duties with this. Have you seen anything about this, Nick, as well, with new entrants?
Yeah, as you say, I mean, there's some concern across the sector because this is a great discount to rely on for a lot of people, and the fact that it's been tightened up is frustrating considering that we've had the increase of fees in the last year. So yeah, we have to keep an eye on it and see what happens.
Yeah, it's really interesting. Another part of the statement of changes, which has actually caused a slight bit of controversy between legal professionals with the interpretation of it, is a new section about salary deductions. So the amendment states that deductions from a salary or repayments of loans and investments will be actually subtracted from the worker's salary, and this will be averaged over the length of time that the applicant's being sponsored for the purpose of salary considerations. So this could actually affect a huge number of businesses who assist with loans to workers, which is quite common, to be honest. We see it quite a lot with people and with businesses. So they can, when an organisation is sponsoring a worker, sometimes they offer some kind of repayment loan to do with the immigration health surcharge, the IHS, or with application fees and priority fees, or with, sometimes they like to apply for their dependents, so their partners and children application fees. So we may see that this new amendment could actually lead to pushing salaries below the minimum salary threshold for the particular occupation code for skilled workers, and this could cause issues which could lead to potential refusals and the employer's potential non-compliance with their sponsor duties. So this is a massive change that was not previously clarified. So yeah, it'll be quite an interesting one to see how that develops.
Yeah,
And
it was
yeah,
horrifically drafted, wasn't it?
yeah.
As you were suggesting, because it was set out in the statement of changes, but no one can make heads or tails of what they actually mean by this, what the Home Office are trying to do. It seems to be an attempt to try and stop what they call self-sponsorship, although what they actually mean by that and what they mean by these changes is up for debate. So as you suggest, there's still a lot of information to come in. It's not clear what they intend here and what the intention is, and we're hoping for an update quite soon on those points as well.
Yeah, exactly. And another thing is that investments are now explicitly covered in this section for salary deductions. So, as you were saying, with a kind of self-sponsorship almost, it was previously viewed as a sort of loophole in the immigration system. So, it was where incoming workers to a company could actually almost invest in the company and therefore cover the cost of their salary. So, it was like self-financing almost. But as you're saying, it's very confusingly drafted, and we are awaiting further clarification. So keep your eyes peeled for that. And everything that we've discussed as well, just in the statement of changes section, all of these amendments are part of the government's wider plan to prevent the exploitation of workers and uphold the integrity of the sponsorship system. So it will be interesting to see how it all pans out, especially regarding the salary deductions, because like I said, that's quite, you know, all up in the air at the moment, and
Yeah.
different legal professionals always have different interpretations of it. And yeah.
Yeah, exactly. And in terms of upholding the integrity of the sponsorship system, as we've talked last time, there has been a huge increase in compliance action from the Home Office. So they've
Yeah.
given themselves a lot more ammunition to take compliance actions because there's a lot more grounds for which sponsors may no longer meet the duties or may be caught out. So it is interesting. It's an area of law that's certainly being tightened up by the Home Office. So we'll have to see how this develops as well. Then on top of all of those changes, if that wasn't enough, we've had a few changes to the global talent route as well in the statement of changes. So most of those come into effect from 9th of April, so there's a bit of time, but not loads of time. And they're largely sort of a tidying up exercise. A lot of routes under the global talent option, which is for those who are exceptionally, i.e. world leading, or exceptionally promising, i.e. potentially world leading in a number of specific fields. They first of all have to apply for an endorsement, and there's a variety of different requirements depending on the endorsement body you choose. But they're now sort of standardizing it to a degree. So basically, almost everyone has to provide a CV now. That didn't used to be the case. It is quite helpful providing a CV, provides a clear narrative as to how you meet the requirements, so that's quite a positive aspect. Letters of support generally needs to be from organisations or individuals that the applicant has directly worked with in their specialty. That's slightly frustrating. It's often the case that you need to provide a letter from an organisation based in the UK, and that may be harder for certain applicants. So hopefully there'll be greater clarity on that as well. And similarly, the British Fashion Council, who one of the sort of sub-endorsing bodies almost effectively, they've made a few minor changes as well, including in relation to media recognition and their letters of support. One of the biggest changes was PACT, which is the Producers Alliance for Cinema and TV. Essentially, this is a very tough route to go down. If you do work in film and TV, often the only way to meet the requirements is to have won a major award, what they call a Notable Industry Recognition Award, or be nominated for such an award, which excludes a lot of very talented people. It's a huge, in my opinion, huge oversight of the Home Office system, that they're sort of stopping a lot of talented people applying under this route. But they've restricted it even further now by suggesting that you can't meet the requirements by a collective award. It has to be an individual award, which is incredible, although there's some exceptions to that. So we have to see how that pans out. But as I say, it's a hugely restrictive route in any case, especially compared to other endorsement routes, and it's been restricted even further now, which is really frustrating as well. On top of the statement of changes, there has been some additional business news. There was the Prestwick care home case. This is a classic case as to trying to appeal to the sort of Home Office humanity, which hasn't unfortunately worked. So we've talked previously about how there was a case where the Home Office lost in relation to a sponsor license revocation, which we all found very exciting because the Home Office write the rules on Home Office revocations and so often win cases which people who bring to court in relation to trying to challenge their revocation. In this case, it was a joint appeal on two cases. The question was where a mandatory ground for revocation is established, so when there's been a clear sponsor breach, for instance, do the Home Office, do they have to assess the potential impact of the revocation on the sponsor's business, its employees, and those who receive care services and the wider care industry? So the care home operator in this case, they had a very serious breach. They argued that deciding whether to revoke a license, the Home Office should be required to balance the interests of immigration control with the impact of revocation on the health and social care sector. I think that was quite an optimistic case to make myself, and the court indeed affirmed that the Home Office was not obliged to consider the consequences of revocation on health and social care, and its role is instead to maintain compliance with immigration control. That does make sense if every industry could argue that the Home Office should take sort of account into whether their revocation would affect the industry as a whole. Then the Home Office would have to become experts in a lot of different industries, and I think that could lead to a bit of madness. As I say, the Home Office are, they write the rules in relation to who gets a sponsor license, and then they are the ones seeing whether you meet the requirements of the sponsor license. So they are, in effect, for want of a better term, judge and jury, although of course in this case you actually go to a proper judge once you've had the revocation. So it's not surprising to see the Home Office have won this case and have restricted the grounds for which people can try and challenge revocations to very narrow grounds, i.e. have you complied with immigration control, those rules that the Home Office have set. We did see a glimmer of hope, however, that the Home Office must still comply with procedural fairness. There was a minor point in one of the cases that the Home Office made an allegation which wasn't brought to the attention to the sponsor during the sort of suspension process, and the Home Office ruled that that should have done, and the Home Office actually lost that one of those cases based on a procedural fairness point. So although the Home Office are effectively judge and jury, they still have to proceed fairly, which is, as I say, a glimmer of hope in a system that is overly controlled by the Home Office. So on top of all of that news, we've also got some updates on the eVisa system. So Sarah, do you want to just talk us through what that is and what the news is as well?
Yeah, of course. So we touched on it in our last two podcasts as well. But the eVisas are part of the general digitalisation of the immigration system in the UK. So the UK government and UK VI, Visas and Immigration, and the Home Office are just trying to kind of bring us in line with the EU and the US and all of these other places that actually have very well working digitalised systems. So there has been a couple of issues with, errors that people have encountered. I was on a meeting last month actually with the Home Office, and there was another legal professional from somewhere saying that they had multiple clients who just had completely different nationalities on their e-visas or different dates of birth, wrong end dates of their leave, which obviously can be, quite dangerous when they need to use the View and Prove service to prove that they can work to employers and landlords and stuff like that. So yeah, they do have an eVisa error correction form, which you can Google online and is linked on our pages, but unfortunately they've not really released any information about when they're going to fix these bugs, so to speak. So yes, this is what's going on. And one nice bit of news actually, which is quite good for a lot of people, is that the eVisa grace period was extended. So biometric residence permits were valid until, predominantly, for the most part, until the 31st of December 2024. So it was expected that from the 1st of January 2025, you would not be able to use them to prove your status, which would make sense because the date has expired. But they did actually extend this to March, and it's now further been extended to the 1st of June 2025. So the Home Office announced, said that it was in line with our ongoing commitment to ensure a smooth rollout. We are announcing today that this measure will be extended for a further 2 months, up to and including the 1st of June 2025. So unless the Home Office further extends this deadline again, it means that from the 2nd of June, individuals will no longer be able to use their expired BRPs and BRCs to travel to the UK and prove their status, and they must instead ensure that they have their e-visa set up and showing the right details in order to prove their immigration status. But it is also the second time this has been extended, so wouldn't be surprised if it's further extended again.
Yeah, these things come in 3s, 4s, 5s, don't they? So yeah, it's like
do.
the EU settlement scheme to an extent. You could apply after the deadline for a long old time. So I wouldn't be shocked if we see this roll
Exactly.
on and on this supposed deadline.
Yeah, exactly. And, like we were saying, which Cathryn's going to touch on later with regards to NTL applications, so the old school ILR vignette endorsements almost people have, or wet ink stamps proving that they are allowed to be in the UK and they're settled in the UK. We've seen some from clients that are from the 70s, and it's expecting people like this who've had ILR since the 70s to go through this whole application process, a biometric appointment, set up their UK VI account, link it to their eVisa. It's quite a long process, especially for people who are, maybe less tech savvy and stuff like that. So yeah, it'd be interesting to see if they further extend this grace period. So keep your eyes out for that. Another update that we've seen, which is quite interesting, is the draft code of practice indicating that facial image updates may be mandated once every 10 years or every 5 years for children. So the UK Borders Act 2007 has a draft code of practice about the sanctions for non-compliance with biometric registration regulations. So this kind of ties into what I was just saying on, people who, for example, have held ILR for decades and decades and have, never particularly needed to enroll their biometric information, and they've just been living in the UK, settled. A lot of them have had, own property, have kids, have worked here most of their lives, and they're kind of being forced to go through this application process and update this. And you do see a couple of people who don't want to give their fingerprints and their photograph, which is your biometric registration, and they look at your signature as well. So, this may cause a couple of issues for people who prefer not to do things like that. But we are awaiting further clarification on this towards the end of the month, so we will keep you all updated. And there's this sanctions policy has guidance circulating, and I was on a Home Office meeting a couple of months ago where people were asking the Home Office, when will it be introduced? How will it be communicated to e-visa holders? When will the sanctions actually come into play? And there was a really good point about how will they reach marginalised communities and the older generations. So, if they're going to subject people to fines and potentially even, criminal charges because they won't update their biometric information, that's quite a significant change. So be interesting to see how that pans out.
Yeah, I find this really quite concerning as to how they will manage that in practice, because obviously we're seeing how that's working now with the eVisa system with NTL applications, and it's not going very well. We still have people, contacting us who have been told by chance that this is something that they need to go through. People just aren't going to be aware of it, and it's just an endless process then, isn't it? Unless somebody naturalizes, they will constantly be subject to updating that information, which is really tricky. And then as people get older, they will lose track of that inevitably.
Exactly.
But yeah, and it's the Home Office haven't really given any firm clarity on the long-term position of legacy document holders. So as you've just mentioned, Sarah, these are individuals with indefinite leave to remain, for example, in a vignette or a stamp in a previous passport. And we're still waiting some further clarification there. So the latest update on 27th of February stated that people with indefinite leave to remain who use an ink stamp or vignette in a passport to prove their rights can continue to use their documents as they do today, including for travel, but are encouraged to make the switch to an e-visa to take advantage of the benefits it brings. But obviously we're hearing from legacy document holders who are now having difficulties at the border since the implementation of e-visas. So for example, one person with a legacy ILR document was told they couldn't board a flight without having an ETA, which is obviously not appropriate in these circumstances because she has indefinite leave to remain and isn't entering, as a visitor. So that's quite concerning. And we're also receiving inquiries from people saying that employers are not wanting to accept legacy documents to make right to work checks. So it's becoming quite a hostile situation for legacy document holders, and the Home Office haven't provided any clear guidance on how these individuals will be protected long term. So they're sort of saying the right things by saying that they can continue to use those documents as they do today for travel, but it's not addressing the fact that actually the e-visa system is making their life difficult. And they're encouraging people to make these applications, but yeah, not really addressing the issue at hand here that's being caused by the e-visa and digitalisation as a whole.
Exactly, yeah. And it's been difficult, hasn't it? Because we've seen so many people who, like you're saying, do have the legacy ILR documents and they're being told incorrect information by travel agents or,
This is the thing, yeah,
there's
it's
no
really, really
information in
worrying.
airports, there's nothing.
People are in the dark really until they come across someone who can provide that with that information. And we're obviously of the opinion that a no time limit application, which is an application to switch to an e-visa, is actually essential at this time to avoid these situations that people are encountering. And obviously the Home Office stating that this is just encouraged is not particularly helpful.
Yeah, exactly. And we've talked before about how many adverts we've seen for the e-visa scheme, as you say. I think last time one of us saw one. I don't know if anyone's seen any more since then, but I certainly haven't. Yeah. So yeah, as you say, there's a lot of holes in this, and no wonder they keep extending that deadline because frankly, the Home Office done a pretty poor job trying to tell people about it. So yeah, we'll have to see how this develops. And speaking of developing, we also had a few changes to the EU settlement scheme in the statement of changes as well. Carla, do you want to just run us through that as well?
Yeah, sure, Nick. So yeah, we've seen like a few changes as well affecting the Appendix EU and Appendix EU family permit. These changes again come into force from the 9th of April 2025, and some of the changes, just to mention some, for example, that the changes allow non-EEA nationals applicants to use a BRC or BRP for up to 18 months after its expiry as proof of identity and nationality and without having to enroll fingerprints. Changes are also that there are changes that confirm that a person with a pending administrative review of a EUSS decision who has not left the UK or who has been granted entry to the UK will not be removed from the UK. And other changes affect like those who have naturalized as after the end of the Brexit transition period, which the changes make clear that they cannot sponsor EUSS family permit applications. On the EUSS front, we're still seeing applicants and clients being confused about how this scheme applies in practice. That has not that is happening because of the scheme, the way it's been drafted, the way it's been interpreted, is not always been very easy, and also there has been loads of changes affecting the scheme in the last few years. In this podcast, I just wanted to clarify a few key points for those under the EU settlement scheme as to how they need to understand the scheme, the continuous resident requirement, as well as the absences. So just to clarify for the audience, that when looking at the meaning of continuous qualifying period of UK residents, there are two conditions that EU nationals, EU citizens must satisfy: to have been resident in the UK by the end of the transition period, it's the 31st of December 2020 at the latest, and after they started the UK residence period, they must maintain continuous residence for 5 years. Of course, as is obvious, sponsored family members can begin a continuous UK residence period at any time. And so the requirement of having lived in the UK by the end of the transition period naturally does not apply to them, but it does to their sponsor. Once a person has been granted pre-settled status and they have lived in the UK, resided in the UK since then for 5 years, they can apply to upgrade to settled status. But of course, we know that in January 2025, the Home Office can upgrade them without an application. Okay. However, the current approach is to begin the automation process close to the end of the existing pre-settled status grant, which could be some time away. So we do encourage applicants who qualify for settled status to make those applications and not wait for these automatic upgrades, which may happen or may not. For example, when applicants may not have enough records of their residents in the UK in governmental databases like HMRC or DWP. As we know, once a person has been granted settled status, they can spend up to 5 years in a row outside the UK for Swiss nationals. And late applications, as per today, are still possible in certain cases and where the applicant can show good reason for missing the application deadline. Now, when looking at absences, which is like the point of like confusion sometimes when it comes to the EU settlement scheme, the general rule is that to maintain continuous residence, a person must spend at least 6 months out of every 12-month period in the UK during the 5-year qualifying period. Of course, there are exceptions to this rule when the absences, for example, are for an important reason, and that, of course, include COVID-19 and the pandemic. Okay, so the Home Office guidance, policy guidance contains a non-exhaustive list, but those kind of cases sometimes require applicants to seek advice from legal advisors because it's not super easy to understand how the absences rule apply in practice. In terms of what will happen to pre-settled status holders if the continuity of their residence is broken, in January 2025, the Home Office published a statement confirming that pre-settled status can be cancelled or curtailed where the holder no longer satisfied or has never satisfied the conditions of residence set out in the agreement. Okay, so for these purposes will be the continuity of residence. I mean, it's very important to note in this statement from January 25 that the statement, it says that it can be, not that it will be, okay? And one of the things that are missing from this statement, which is of very importance, is the fact that the statement does not include the fact that in line with the withdrawal agreements, resident status under the withdrawal agreements can only be removed where a person has ceased to meet the resident conditions and also when it's proportionate to do so. Okay, so this means basically that breaking the continuity of resident conditions alone is not sufficient for someone to lose their resident status. There needs to be as well an assessment of whether it is proportionate or not to take away the resident status. And of course, based on the individual circumstances. Okay, so we are currently at this stage waiting for Home Office policy guidance. Would engage more on the issue of how to assess the proportionality of removing a status. Okay, once this has taken place, possibly this year, we will be in a better position to understand the impact of not satisfying the continuous resident requirements. We'll definitely keep you updated on any developments on this front, and we will publish any further information we know on our website, and probably we're also going to discuss it in future podcasts. Two further final points on youth mobility and EU migrants. It's worth mentioning quickly that the academic think tank UK in a Changing Europe published an analysis on the 24th of March 2025. The analysis examines the ongoing negotiations over a proposed EU-UK youth mobility scheme. Okay, so for those who are not aware, this potential scheme, which was firstly proposed by the European Union in April 2024, would allow citizens aged 18 to 30 to stay up to 4 years in the destination country under restricted conditions. The UK government, with honesty, has shown reluctance to engage with the EU-wide proposal, and instead are preferring bilateral agreements with individual member states. The analysis done by the organization highlights that the scheme differs from freedom of movement rights, as it requires visas and does not grant settlement rights or unrestricted movement across EU member states. So yes, it's worth checking this analysis, which is published in the website. And finally, a reminder to all European visitors that they can now apply for an electronic travel authorization to travel to the UK. And in fact, they will need one if they intend to travel to the UK from the 2nd of April. So that will be from next week. While most applications are approved quickly, it is still recommended to allow up to 3 working days to count for the small number of cases that will require additional review, etc. So we encourage, people to apply in good time. At the moment, it currently costs £10, but as we discussed in this podcast, it's going to increase to £16. And the ETA, once obtained, will allow multiple visits to the UK of up to 6 months over a 2-year period, or until the holder passport expires, okay, whichever is sooner. And again, a reminder to our audience that an ETA is not a visa, it's a digital permission to travel. So this is all in the EUSS front, but we will keep you updated, especially on what we said earlier about the Home Office policy guidance on proportionality and potential curtailments, which we will be seeing more and more, I guess, as time goes.
That's great, Carla. Thank you for that. That was really detailed on the EUSS, and so glad to have you as our resident EUSS expert. So that was excellent. So we have a number of articles on some of the topics we've discussed today. We've got one on the ETA on our website, as well as our eVisas page, and we've also got an article on the statement of changes, as well as a number of fixed pages on some of the areas we've discussed, like skilled workers and global talent. So do look at our website for information on all of those, as well as Carla was saying, any updates in the future. And that brings this episode to a close. Thank you for joining us. Do keep an eye on our website for further information, and look out for further episodes of our Immigration Insights podcast, brought to you by Carter Thomas Solicitors. Bye-bye, and thank you for listening.